Thank you, Mr. Chairman. I apologize if I re-ask a question. The governor of Texas was in for lunch, and you don't upset Mr. Perry by no-showing on him. I did want to talk a little bit about the patent assertion entities. In Texas, if you buy groceries, there's a pretty good chance you buy them from H-E-B. It's a big grocery store chain in Texas, and believe me, they get plenty of my money. But one of the reasons the prices might be so high is they tell me that they were approached by one of these entities for a device that reads checks. They bought it off the shelf and plugged it into their system, and they were basically say, "Hey, settle with us now, or we'll run this through litigation, and it'll be 10 times the cost." And you see this happening to, I see JCPenney's has mentioned that it's happened to them. My fear, all right, I've got a lot of electronics. I've got one of Adobe Photoshop Touch on my iPad. If you guys unintentionally have something in there that's infringing, you'd expect the patents to be asserted against you. But if I take this to its logical conclusion, they could come sue me for more than I paid for my iPad, more than I paid for the software on my iPad, and potentially more than I made this month. Think that's an accurate statement?
Unfortunately, they are allowed to sue you. That is correct. They're allowed, as Mr. Chandler mentioned earlier, they're allowed to sue the user of technology if that method is patented. That's the law today. I think the question, of course, for you particularly is damages, but I think Adobe, generally, we stand behind our software. As Ms. Dillon mentioned before, we work with our suppliers and our customers, and when we find that someone's accused of Photoshop of infringing a patent, we'll step in and intervene.
And you've been approached by customers to do this?
We have. Safeway, another grocery store, has asked us to do this. REI has asked us to do this. LL Bean has asked us to do this. I mean, Pacific Sunwear has asked us to do this. Small retailers are asking Adobe to step in these.
So what percentage of your patent litigation comes from these patent assertion entities?
About 85% of our patent litigation is
85%.
Yeah.
All right, I'm a little bit concerned again. I guess it's an enlightened self-interest because I'm an early adopter of technologies. But I think would a solution be legislatively create an end user exemption where if I go buy something off the shelf and don't modify it and use it the way it was intended, and just plug it into the USB port of my computer or plug it into the wall or whatever I'll go down the line. Does anybody see any problems with that? And would that be at least a stopgap solution? Anybody want to take a stab at that? Ms. Johnson?
Under the Uniform Commercial Code, there's already an implied obligation, implied indemnity against non-infringement from a manufacturer to a customer. So, and the prevailing jurisprudence is that customer suits like we're talking about should be stayed in favor of a manufacturer resolving the issue.
Oh, yeah, I guess my fear is, and I practiced law for a while, and one of my lines to my clients where you can beat the rat, but you can't beat the ride.
Well, that's exactly the problem, is that some courts have ignored that jurisprudence, which is why a statutory fix may be required in order to get rid of this problem. But I don't think that you have to wholesale deprive a patent owner of a right where there really is an infringement in order to do that. It may be that you'd have unintended consequences because the only person who could be sued might be the one you would exempt, and you wouldn't want to do that.
Congressman, if I could just echo that, there are certain patent claims called method claims that are only infringed in some cases by the end user, and so that's the issue that Mr. Johnson's speaking of. So it adds complexity to what you're trying to achieve.
All right, well, I appreciate it. I see I'm just about out of time, so I'll yield back.